We often don't think about criminal justice or law in the ancient world, but it did exist, and in Athens specifically, it laid the groundwork for much of our legal system today. Since I'd rather not waste your time with a long and pointless intro, welcome to a short, concise video on criminal justice in ancient Athens. For much of early Athenian history, the legal system was closed off to ordinary citizens, with most judges being part of the elite ruling class. Over the course of a century, starting in the late 600s BC, the successive reforms introduced by Solon and Cleisthenes began to allow all male citizens, regardless of class, to participate in juries who would decide verdicts rather than judges. Athenian trials came in two forms, private and public. In private cases, only the individual who had been directly wronged could press charges. Public cases, however, were considered to be in the interest of the city, and anyone could bring charges against anyone else. There were several courts in Athens, with the two largest and most powerful being the Areopagus and the Heliaia. For most of Athenian history, most trials were brought before the Areopagus, while the Heliaia mostly judged government officials. This changed in the 460s BC when the politician Ephialtes introduced reforms that removed many civil cases for the jurisdiction of the Areopagus and put them under the Heliaia, limiting the Areopagus to certain murder cases. Specifically, regarding bodily injury or death, Athens had 5 specialized courts, each with its own jurisdiction. The Areopagus, for homicide, arson, and poisoning. The Palladian, for involuntary killings and the deaths of slaves or non-Athenians. The Delphinian, for, quote, lawful killings, like self-defense. The Phreato, for murder committed after being pardoned for a prior offense. And the Prytanean, for cases involving animals, inanimate objects, or unknown killers. Athenian juries were massive by today's standards, usually numbering between 200 and 500. This was done in order to reduce the risk of bribery. In the case of the Heliaia, there were 6,001 jurors, who were randomly selected from the Athenian populace every year. Eligible jurors had to be male citizens over 30, not enslaved, not in debt, and without a criminal record. These jurors were divided into 10 groups of 500, with 1,000 extra as substitutes. For each trial, a lottery would select between 200 and 500 jurors from a single group. At the start of a trial, both parties would swear to the judge or magistrate presiding over the trial that their accusation was true and genuine in the case of the plaintiff, and either protest innocence or admit guilt in the case of the defendant. Trials resembled debates. The plaintiff would present his own arguments and evidence, followed by the defendant. There were no lawyers, each citizen argued his own case, though the wealthy would often hire legal scholars to write their speeches for them. After both sides spoke, the jury would vote secretly. A simple majority was enough to reach a verdict. In public cases, if fewer than 1/5 of the jurors voted in favor of the plaintiff, he would be fined 1,000 drachmas and banned from filing similar lawsuits in the future. No matter how serious the charge, all trials took place over the course of a single day. Now, as an example, let's take the case of Socrates. In 399 BC, 3 Athenian citizens charged the philosopher Socrates with impiety and corrupting the youth. The public trial followed standard procedure, and in the end, 280 jurors voted guilty, while 221 voted not guilty. Then the jury debated the punishment. A fine of 3,000 drachmas was originally proposed, but after much deliberation, the jury instead sentenced Socrates to death by drinking poison. Athens had no police force in the modern sense. The government did own around 300 Scythian slaves to keep the peace, but they usually didn't make arrests. In serious cases like murder, it was up to the victims' relatives to apprehend the accused themselves. Alternatively, they could pay a magistrate, usually around 1,000 drachmas, to carry out the arrest. In less serious cases, a court would simply send a written summons. Thanks for watching. If you enjoy history content like this, please consider liking and subscribing. And as always, credit goes to these people for some of the images shown here.